Looked like we had an audible issue there for just a moment. So I am Frosty Walker, Chief Information Security Officer with the Texas Education Agency, and welcome to Cybersecurity Tips and Tools. Today we're going to talk about data privacy agreements, and we hope you find this information informative. This is the third in a series of webinars regarding cybersecurity for the spring semester of 2018. We will allow time at the end of the presentation for questions and answers. Should you have a question during the presentation, feel free to submit them, and we'll get them queued up for the question and answer. So I am seeing that people can hear me, and that you can see my screen as well. So thank you very much. I do want to talk just a little bit about the DSAC, or the Data Security Advisory Committee, that we've had now for quite some time. It was designed to provide guidance to the Texas education communities, maximizing collaboration and communication regarding information security issues and resources which can be utilized within the educational communities served. The DSAC currently is comprised of representatives from school districts, ESCs, TEA, and the private sector. The DSAC is diverse both in size and in geographically, and we are willing to share needs and ideas and time to hopefully provide solutions to everyday cybersecurity issues. I want to take this time to thank everyone who participates on that committee. If you're interested in participating, please drop me a line. We're always looking for new and innovative things to address within the DSAC. So if you're interested, this is open to anyone that would like to participate. So thank you. A recording of the webinar today will be posted on Cybersecurity Tips and Tools, and that's located on our Texas Gateway at https://www.texas.gateway.org under Cybersecurity Tips and Tools. And if you're at that URL, you will see Cybersecurity Tips and Tools under the featured resources. So why do we need a data privacy agreement? And in some cases, you may not. If you cover the material in your contracts and in your contract negotiations, then you may not need a data privacy agreement. However, most of us like to prefer to have a data privacy agreement that is separate from our contracts. There is an effort to put together a template of a data privacy agreement that all school districts could use across Texas. That effort is being led by Nancy Fuller from the Houston Independent School District. I want to thank Nancy for that effort very much. This has been done in New York, the state of New York, as well as in California. It is the intent to have that template ready for the schools to be able to use by the fall semester. But we wanted to go ahead, give you a little bit of preview about what you're going to cover, what may be covered in that, and general ideas that in case you're negotiating with contracts now that you may want to cover. And the reason that we really need these terms and conditions is because you can outsource everything except responsibility. And that's a quote from John Keel, our former Texas state auditor. And so what we're going to try to do is show you ways that we can, although you can't outsource that responsibility, you can make sure that you're covering it in contract language of what's going on. I'm getting some notes here that says they're having trouble hearing me and it's cutting out from time to time. we're going to work on that in just a second. I apologize for the inconvenience. We'll see if that helps. So first of all, when we talk about data privacy agreements, we want to talk about what is involved, what's in the scope of that. And we're going to talk about an operator or a vendor or a partner, someone who is going to provide services to us, in this case, the local education authority or LEA. And it may be necessary for us to share certain information related to students, employees, business practices, or intellectual information. And this agreement describes the responsibilities to protect the data between the LEA and the operator, because ultimately the responsibility still falls on us to make sure that we're taking proper care of that data. We'll talk a little bit about data ownership and authorized access. Data. All data transmitted to the operator pursuant to this agreement will continue to be the property of and under the control of the LEA. All rights, including all intellectual property rights in and to the data contemplated per this contract, shall remain exclusive property of the LEA. And I'll try not to read all of these slides to you. So the two basic concepts here is, one, the data belongs to us and it is under our control. And number two, the piece about the intellectual property. Any intellectual property that is contemplated through this contract is also our property. I'll give you an example of what we talk about when we're talking about intellectual property. So you say you enter in an agreement with a vendor who has pieces of this that what you need, but you want some specific information developed for your application. Who would own that piece that was developed for this application? If you develop the whole application, then that's your intellectual property according to this. The vendor may say, hey, I really want to resell that to some other folks, and they may want to keep that property. But that, if you're paying them to develop that under this contract, then you more than likely want to retain the ownership of that. So you want to make sure that you have that in the contract. If you don't want to retain ownership of it, then you may not want to include that clause. But that's what that clause is about. So anything that they develop on your behalf under this contract, you could say that is your property as well. Parent access. And we notice that this starts off saying LEA shall be responsible for procedures by which a parent or legal guardian or eligible student may review data on the pupil's records, correct erroneous information. So what you want to do is you want to make sure they may have procedures, but if they do, then you want to make sure that those are the procedures that you want to specify. So it may be that you want to specifically establish those procedures of how the parents or how the students are going to access and review their data. Again, you want to specify that explicitly in the contract. Third-party request. Should a third party, including law enforcement or government entities, contact your operator or your vendor with a request for data that's held by the operator pursuant to these services, the operator shall redirect the third party request of the data directly to you, the LEA. You don't want that operator to just hand somebody information. You want to know why somebody's requesting that information, and you want to be able to say, yes, I approve of that. Certainly in law enforcement, you're saying, well, I'm going to probably approve of that, but you want to know why law enforcement might be wanting to look at that code, look at that data. The operator shall not use, disclose, compile, transfer, sell the data and or any portion thereof to a third party or other entity, or allow any other third party or other entity to use, disclose, compile, transfer, or sell the data or any portion thereof. So again, you want to be able to have control of the data that's being shared under this service agreement, and you want to explicitly state and make it clear that the operator is not supposed to use this for anything other than services described in the agreement. Subprocessors or subcontractors, and this is something that we have a problem with from time to time. So we want to state that the operator shall enter into written agreements with subprocessors or contractors to perform functions pursuant to the service agreement, whereby the subprocessors agree to protect the data in the manner consistent with the terms of this agreement. So should your operator use a subprocessor or a subcontractor, you want that operator to hold that subprocessor to the same terms and to protect the data as you want to hold the operator to. And we run into problems with this all the time when we're dealing with large vendors who may say, well, I'm going to take this, I'm going to do this, but I'm going to award a certain piece to someone else that's going to do this piece, who then may award and use somebody else to do another piece of that. So now we have sub-processors or subcontractors who are operating to subcontractors, and trying to make sure that you enforce how you want your data protected is key. So by including a statement similar to this, that you want to protect the data in a manner consistent with the terms of this agreement with any other sub-processor, will help you cover those responsibilities. Let's talk about our duties. Let's talk about the duties of the LEA. So first of all, we are going to provide data in compliance with state and federal law. The LEA shall provide data for the purposes of this service agreement in compliance with FERPA, COPA, PPRA, Texas Education Code, Chapter 32, and all other Texas privacy statute quoted in this agreement. So we want to make sure that we cover all of those. FERPA, Family Educational Rights and Privacy Act; COPA, Children's Online Privacy Protection Act; PPRA, Protection of Pupil Rights Amendment. So those are all things that may have that we may need to have compliance to when we're sharing that, as well as Texas Education Code and other privacy statutes. So we want to make sure that we outline those within the agreement. Unauthorized access. And remember, we're still under duties of us, the LEA. And the LEA should notify the operator promptly if any known or of any known or of suspected unauthorized access. So if you notice that the application is not working properly, or if you log on and it says, oh, the last time you logged on was at midnight, and you know you didn't log on at midnight, then you need to contact that operator and say, hey, there may be something going on. would you please take a look at this application? And of course, you also want to be able to help the operator and to assist them to investigate and to respond to any unauthorized access. So you're saying, hey, I'll notify you if I see anything. And we'll cover more about what the operator is responsible for a little bit later. In fact, let's cover that right now. So first of all, let's talk about privacy compliance. The operator shall comply with all applicable state and federal laws and regulations pertinent to data and privacy and security, including FERPA, COPA, PPRA, Texas Education Code, and other Texas privacy statutes as quoted in this. So now we're saying that, hey, operator, you also have to comply with these same things. Just like I had to comply when I shared with you, now I'm expecting you to comply as well. The party agrees that the operator is a school official under FERPA and has legitimate educational interest in personally identifiable information for education records for purposes of the contract. An operator is either providing a service or a function which the LEA would normally use employees for, or is under the direct and it's under the direct control of the LEA, and it's also subject to the requirements of FERPA. And this is a clause that we put in here in these agreements because of the way that FERPA is worded and school officials. So you want to make sure that you're saying, hey, I'm authorizing them to do this work for me so that it's in compliance with FERPA regulation. Authorized use. The data shall be, including persistent unique identifiers, shall be used for no other purpose other than the services stated in this service agreement are otherwise authorized. So you do not want this data being used for anything other than what's defined as the services within this agreement. The operator also acknowledges and agrees that it shall not make any redisclosure of any data or any portion thereof, including without limitation metadata, user content, other non-public information, or personally identifiable information contained in the data without express written consent by us, LEA. What this is basically saying is, again, even if it's metadata, even if it's user content, we do not want our operators, our vendors, or our partners sharing any of that information without express written consent from us. Employee obligation. From the operator's standpoint, operators shall require all employees and agents who have access to the data to comply with all applicable provisions of this agreement in respect to the data that's shared. The operator agrees to require and maintain an appropriate confidentiality agreement from each employer or agent with access to the data pursuant to this service agreement. So what we're trying to express here is, number one, we want you to require your employees to comply with all of the applicable provisions that we provide in this agreement. And we also want you to have and maintain an appropriate confidentiality agreement with each of those. Confidentiality or a non-disclosure agreement, something that says, I will not share this information, I will not access information that is not pertinent to pursuant to my job. Those types of statements that would be included in a confidentiality agreement and we want to make sure they have one on file for each employee or agent. Again, we talked about agent could also potentially be a subcontractor or a sub-processor. No disclosure. So we're going to talk a little bit about de-identified or anomalized information may be used by the operator for purposes of development, research, improvement of educational sites, services, or application as any other member of the public would for use for de-identified information. So when we talk about de-identified or anomalized information, that is information that's readily available on the internet. So they can take that information and then they can actually use that information to make for development and research and improvement of educational sites and services, just like anyone else in the public that might take that information and could utilize that if they wanted to. But again, that is information that has been anomalized and does not contain any type of sensitive or identifiable information. The operator also agrees not to attempt to re-identify any of that anomalized data and not transfer de-identified data to other parties unless the party agrees in writing not to attempt to re-identify or has prior written notice given by us, the LEA, with written consent for such a transfer. And the operator shall not copy, reproduce, or transmit any data obtained under this service agreement except necessary to fulfill this contract. So we're getting into some very specific details about how we're going to use that data, but it's always referring back to the services as provided within this agreement. Let's talk a little bit about deposition of data, how they're going to destroy data. And people think about this at, well, at the end of a contract, we're going to ask them to destroy the data. And that's not, a lot of times that's not the case. You may request them to destroy specific data at any time. I can remember we had a legislative mandate 2 sessions ago in which we had to expunge data from all of our records. So in essence, the legislation was saying, hey, we want you to dispose of this information in every place that you have it. And so we had to go out and do that. There was no end of a contract. And the same thing is true here. The operator shall dispose of or delete all data obtained under this service agreement when it is no longer needed for the purpose in which it was obtained and transferred, and said data to the LEAs. Deposition shall include shredding of hard copies of any data, erasing or otherwise modifying personal information in those records that make it unreadable or indecipherable. And those last 2 are key: unreadable or indecipherable. Additionally, the operator shall provide written notification to us, the LEA, when the data has been disposed of. The duty to dispose of the data shall not extend to data that has been de-identified or placed in a separate student account pursuant to other terms of this agreement. So we talked a little bit ago about de-identified information and how they could use that. So in this case, we're saying, hey, if we ask you to destroy information, you can keep that de-identified information, but we want you to destroy all the original data or any of the data that might have sensitive information in it, we're going to ask you to destroy that. In this particular case, it also goes in and talks about that, we could deploy a request for return or deletion of data form. And in this case, it says upon receipt of the request from the LAA, the operator will immediately provide the LAA with any specified portion of it within 3 calendar days of the receipt request. Now, you could extend that time. These are times that are set as examples, but and you may not feel that that's necessary to include that. But if you at any time think you may request to return or delete information, you want to set a specified period of time when they're going to do that, and they have to notify you of how that's done. In today's environment, when we're dealing with a lot of operators that put things out in the cloud, there's always a question that comes up, well, how do I validate that that data was indeed unreadable or indecipherable? And that's very difficult to do. So you want to specifically state how you expect them to do that. In their notification, I would also expect them to tell me how they made that data unreadable or indecipherable, so that at least I can look at that and say, okay, yes, you wrote over this 7 times. That's probably going to be okay. That data is not going to be is not readable any longer at that point. But anyway, we want them specifically, we either communicate how they do it, or we want them to communicate to us how they accomplish that, because it is difficult to verify that information. This is a subject that has gotten a lot of publicity over the last 18 months or so. The prohibition of advertising. The operator is prohibited from using or selling data to market or advertise to students or families and guardians, to inform, influence, or enable marketing or advertising or other commercial efforts by an operator. They cannot develop a profile of a student or the family or a group for any commercial purpose other than those providing the service within to the LEA that's specified within this agreement. The use of the data for the development of commercial products or services other than as necessary to provide those services within this agreement. This section does not prohibit the operator from generating legitimate personalized learning recommendations. So we look at that and say, well, that last sentence might have been added by a partner, a vendor, or an operator to allow them to generate legitimate learning recommendations. And if that's the purpose that they're going to use that data, then that may be acceptable. Data provisions. So passwords and employees access. Operator shall secure usernames, passwords, and any other means of gaining access to the services or to data at a level suggested by Article 4.3 of NIST 800. And this is the National Institute of Standards. And if you go to their 800s, particularly Section 63, it talks about standards and best practices for managing secure passwords and data. So in this case, we're pointing them directly to a document that tells them best practices on how to manage and protect that information. Operator shall only provide access to data to employees or contractors that are performing services. We do not want them to provide information to someone that is not working on our services. Again, that goes to the principle of least privilege, where only if you have need to know should you be accessing something. Additionally, in this particular clause, we say all employees with access to our data shall pass a criminal background check. And I think that that's another key importance. We want to make sure that our operators or anyone that has access to our potentially sensitive information has indeed had background checks. And when we're dealing with vendors, we're dealing with operators, the only way to make sure of that is to make sure we include that in the contract. And I'd also state that we would want to make sure that they have passed a background check prior to accessing our data. I was working in an environment and we had a contractor providing us with employees that were accessing information, and they called one day and told me that someone would not be reporting into work. I said, oh, okay. Are you going to send somebody else? They said, yes, we're going to send someone else, and you can start training him. And I said, oh, is this person no longer coming back? And they said, yes. He didn't pass his background check. And that concerned me, because he had been working for us for 6 weeks. So we may want to include something that prior to them being able to access our data, we want to make sure they passed a background check. Not a year after they pass a background check, they've been accessing our information. Data security. The operator agrees to abide by and maintain adequate data security measures consistent with industry standards and technology best practices to protect data from unauthorized disclosure or acquisition by unauthorized personnel. And then here's a place that we can list what we're expecting them to, some of the measures that they can include, but not limited to. And so we'll talk about some of those, but this is where you would provide a list of some of the things that you would want to include. For example, security protocols. Both parties agree to maintain security protocols that meet industry best practices in the transfer or transmission of the data, including ensuring that the data may only be viewed or accessed by parties legally allowed to do so. Operators shall maintain all data obtained or generated pursuant to this agreement in a secure computer environment, not copy, reproduce, or transmit data, except as necessary to fulfill the purposes of the data request. The data must be encrypted at rest and in transit via best practices. In this type, if we talk about data at rest and best practices, we may state that we may want a requirement of something like 256-bit encryption. But at least we're stating here that it has to be encrypted at rest via best practice standards. So we couldn't have somebody that's using weak encryption methods. We typically don't see that today, but again, we want to make sure that we emphasize how we're requesting our data to be protected. You know, we wouldn't think that we'd need to specify backups in this day and environment, but however, we don't want to leave anything to assumption. Operator agrees to maintain backup copies, backed up at least daily, or of data in case of operator's system failure or any unforeseen event resulting in the loss of data proportion. We don't have to get very specific here, but we could ask the operator to tell us how they back that up, and we would also want to tell them that how do they test those backups, because we don't want to see a disaster and they try to recover from that and find that the last readable backup was conducted 90 days ago. So on a regular basis, they should be testing those backups. In many cases in application these days, we have hot or warm facilities that can switch over with that data if it fails over. So we just need to know how they're providing that. Employee training. The operator shall provide periodic security training to its employees who operate or have access to our data. Operator shall provide the LEA with contact information of the employee who we can contact if there are any security concerns or questions. So we're saying, hey, on a periodic basis, we want to make sure that your employees are getting security awareness training, and we also need the name of a contact should we suspect there's a problem. That sounds pretty simple, but at the same time, it's very key that we include that type of information and request that type of information in our contracts. Security technology. So we'll talk a little bit about secure socket layer, SSL, or equivalent technology shall be employed to protect data from unauthorized access. The service security measures shall include service authentication and data encryption at rest and in transit. You notice we include encryption requirements in multiple locations. So it doesn't hurt to include those in multiple locations to make sure that your operator understands that they're required to provide those services. The operator shall host data pursuant to this agreement in an environment using a firewall that is periodically updated according to industry standards. So while just a firewall doesn't provide all the protection that it needs, it does provide certain limitations in protection, and we want to make sure that it's updated according to industry standards. So we can specify those, and again, they may come back and say, well, here's all the things that we provide in those services. Okay, then we'll put that in the contract as well. Earlier, we asked about they would provide us the name and contact information that we could contact, and in this case, we actually want to request them to have a designated security coordinator so that we can contact that person. So we want them to name a coordinator and then provide us the information on how we can contact that person. We're also going to request that they will conduct periodic risk assessments and remediate any identified security and privacy vulnerabilities in a timely manner. You may want to insert what you think is a timely manner here. I try to specify that we want those remediated within a 90-day time frame. Sometimes we find issues that can't be fixed in 90 days, but in most cases, they should be willing to agree to fix and remediate issues within a 90-day time frame. But here, in this case, we state a timely manner. I personally like to state what we think is a timely manner so that we don't get into the legalese defining timely manner. Say 90 days. Upon request, the operator shall provide the LEA, us, with the results of the risk assessments and will promptly modify its security measures as needed in order to meet the obligations of this contract. So not only do they run vulnerability tests and say they fixed it, you can request copies of that information. So you're verifying that that indeed has taken place. And audits. Upon receipt of requests from us, LEA, the operator shall allow the LEA to audit the security and privacy measures that are in place to ensure protection of the data. Operator will cooperate fully with the LEA and any local, state, or federal agency with oversight authority in connection with an audit or investigation. Failure to cooperate shall be deemed material breach of this agreement. So we want to make sure that we have the ability to audit, or someone that is auditing us, a state auditor or a federal auditor, has the ability and to come in and do an audit, and they're also going to agree in this language to let those people in, have full access to facilities, staff, agencies, and our data, as well as any records pertaining to the services of this contract, to make sure that we can do an audit and cover that to its fullest extent. Incident response plan. So, operator acknowledges and agrees to have a written incident response plan that reflects best practices and consistent with industry standards, federal and state law in responding to data breach security, a privacy incident, unauthorized acquisition or use of data, which could include personal identifiable information. And upon request, we request a written copy of that incident response plan. So we want to make sure that they say they've got one. We want to request that to make sure that in case we have an incident, that they have a plan in place and how they're going to address that. Data breach. When the operator reasonably suspects or becomes aware of a disclosure or security breach concerning data, will immediately notify us, the LEA, and take immediate steps to limit and mitigate the damage of any such security breach to the greatest extent possible. And we'll go on and explain some of the things that we want to see when they notify us of that. So we want to know name and contact information and the subject that's being reported. We want a list of the types of personal information that were possibly believed to have been subject to a breach. The information is, if the information is possible, to determine the time that the notice was provided, and either the data breach or an estimated date of the breach, or a data range in which the data breach occurred. And you have to remember that even in today's forensics, sometimes it's very hard for us to pinpoint when a breach actually occurred. So hopefully we have records and have monitoring tools that they could quickly identify that, but sometimes that might not be the case. So we may be looking at just a range of when that breach occurred. Now, and we also want to make sure that when they send us that notice, that they have the date of the notice on there. Again, date of the notice may be different and could be months after the actual breach occurred. We also want to know if the notification was delayed because of law enforcement investigation. We need a general description of the breach incident and the information that was possible to determine at the time the notice was provided. We would also want to know what mitigation steps are being taken. This is just the notification to you saying, hey, we've had not unauthorized disclosure. We've had a breach. This would also be a section that you could include information that says, okay, Mr. Operator, if there is a breach, we're also going to have you respond and do the notification. And we're going to hold you responsible, not just notification, but also providing some type of security, identity theft protection. You can request that the vendor provides that, knowing full well that there's going to be a cost associated with that if that happens. The one thing, if you want to go that route and use you request the operator to do that, you want to make sure that you have the right to review that information and what's being provided, and to be able to approve or disapprove of that before that information is sent out, because that'll be key. You do not want someone sending something on your behalf that you have not reviewed and you have not approved. Say, oh, okay, well, you send the notification. You don't want that to happen. You want to make sure, because ultimately, as we talked about at the beginning, we are responsible for protecting this information. And that is what our users, whether that's students or whether that's employees, they expect us to be responsible in protecting that information. So we want to make sure that if we're trying to have someone else perform those duties for us, whether even in the notification, that we have the ability to approve that prior to it being sent to our users. So with that, I'm going to open up to questions. It seems like the sound issues. We've worked on the sound prior to this before. I guess our next webinar will be in the fall session. I'll see if we can't get my computer changed out, and we'll do some testing on this again. I do see a comment here that about minimal standard for support. We talked about weak ciphers, TLS1. I recommend that you set that as a minimum requirement. That is the minimum requirement for PCI, DSS, payment card industry data security standards. I think that is appropriate in this case, and I'm pretty sure that TLS 1.2 will be a standard before very long in the future. The question, we do have a question about the sample document that we're referring to, the template. It's not quite ready for release yet, but I think by the summer that document will be ready, and we'll be able to produce that document. And I encourage all of the schools and all of the LEAs to take a look at potentially using that. I think the effort that's been put into this is very good, and I think that a lot of the language will help us provide the protection to help protect the resources that are shared with us by the citizens of Texas. Question, how do we get a recording of today's webinar? It will be posted out on the Texas Gateway. I'll go back to that once again. As well as a copy of all the slides in the presentation today. It will be at the Texas Gateway, https://www.texasgateway.org. And that URL looks like this. Under Cybersecurity Tips and Tools, that's where you'll find the recording of this as well as a copy of the presentation slides itself. Are there any guidelines as to notifications to other LEAs that an operator has given your data to another LEA? Oh, I would certainly think that if somehow you have received wrong information, you would want to try to notify, and you may not be able to tell what that belongs to, or who that belongs to. So I would suggest that you reach out to your Education Service Center and let them know you've received something that looks like it belongs to another education entity. Remember, we may be dealing with something that's not even in state. It may be out of state. Reach out to me. We'll see what we can do, because if that data contains sensitive information, we may be looking at unauthorized access by the time we determine what data that is. So we would certainly want to reach out and try to find that other LEA. So I do think that's a very good. Is there any guidelines for that? Not that I'm aware of in any of our requirements, but I would think my first place to be is to reach out to my regional service center, or to reach out to me. I appreciate that. Will the sample documents be distributed to schools? And yes, it will be distributed to schools when that is available. We may have that ready sometime in June. I have worked with that organization. And like I said, New York and in California have already implemented this, so we had a couple of good models to work off of. But we specifically took that and remodified that just applicable to Texas as well. Does TEA require or any other requirements for Windows updates? Again, we do not have any specific requirements. Best practice is that we roll those patches out. So here at TEA, we roll those patches out to a test group of servers in our dev environment to see how that worked. If we didn't have any impact, we roll it out to all of that environment. We run on those about a week to 10 days, and then we patch our test environment, and then we run on that for 10 days, and then we patch our production environment. And so we try to have those patches deployed within 30 to 45 days. That is typically what I would call industry standard, but we do not have any requirements for that. But your industry standard is to get those into production, certainly on your servers. Workstations, we get those deployed out with we do again a pilot group to see what impact they would have. run on those about 10 days, and then we deploy that to all of our workstations. So we typically get those rolled out within 20 days. But servers that could have a much more major impact, we roll that out a little longer, but make sure that we've tested that in our test and dev environments. What about Google and G Suite for education? And I don't use Google Docs, so and their G Suite. So I'm not very familiar with that, and so I will defer that if there's anybody else that's using, if it's anybody else using Google and G Suite, and what type of, how often are they updated, any of that type of information, I would appreciate you sharing that with us. And then the question comes, how should we respond to some vendors when they don't want to sign a data service agreement with the district because they have TEA, an agreement with TEA, and refuse to sign? Okay. There's a couple of cases where I know that TEA may be collecting data through an operator, and we have data agreements signed with TEA. And I know from time to time that those operators call me and say, "Hey, I got a non-disclosure agreement or a privacy agreement from ABC school district, and I want to know, should I sign it? What should I do?" And I said, "Well, while you're collecting that data on TEA's behalf, and we've tried to negotiate with that. I'm not opposed to school districts saying, hey, we want to make sure that you're taking care of this. And is there anything in that service agreement that is different than what is in our service agreement? And if there is, we want to know about it." So we try to take a look at those service agreements and see if there's some issue as to how we're asking someone to collect that data. And I think that this will help us with that. There may be vendors, hopefully, when we have a template, we can work with vendors and say, this is what we are expecting. This is what we're expecting you to agree to. And if there's a group of us like this that approach them with that, then I think they may be willing to come to the table. We will have to see how the vendor community responds to that. So, well, I think that's yet to be determined. But I know that in New York and California, they had a lot of vendors that have agreed to sign these agreements. Someone states, Fitness Ground, for example, do they sign an agreement with TEH which would cover the LEA? I will have to double check, Jeanette. I'll send you a personal note on Fitness Ground. I'll have to look at the service agreement on that, but I will take care of that. I'll get back with you on that. Are there any other questions today? Well, I'm going to say thank you again very much. I appreciate all the interaction today. A lot of very good questions. We will post these questions and answers out on the portal. So if there's a question that you've asked and you haven't gotten an answer for it, we will post those out. It'll take us a few days, like the Fitness Ground question, before we get that posted. But if you don't find a question and answer for this particular session, let me know, and it may have accidentally been placed in the wrong folder or something. So we should have question and answers for all of the sessions. So I appreciate your support again, and thank you all very much. If there are no other questions at this time, we're going to close this out. And again, thank you for your attention and concern on cybersecurity, and we look forward to working with you all in the future. Thank you.